Hi, happy Valentine's Day, and welcome to the Love Immigration live chat on immigration options for spouses. Today I have with me our legal assistant, Maya Madden.
Hi.
Maya, thank you very much for joining us.
Hi.
How are you doing today?
I'm good.
Great. Well, like I said, we're going to be talking about immigration options for spouses. We're here at the Love Law Firm in Hoover, Alabama. It's a very cloudy day, but I hope everybody's having a wonderful Valentine's Day so far. And so today we're going to discuss immigration options for spouses, including visas for spouses or fiancés, as well as family-based petitions for spouses. We're going to touch on options for someone who has TPS, who has married to a U.S. citizen or permanent resident, as well as options for people who are married to someone with pending U visa or an approved U visa. Am I missing anything?
No. Yeah.
Awesome. And so I just want to say, here at the Love Law Firm, we only handle immigration cases. And if you have any questions, feel free to reach out to us. Our phone number is 205-323-8727. You're welcome to submit a question here on Facebook, and we'll answer it live. Maya's monitoring our questions that we get in. And you can also shoot me an email at it's jeremy@loveimmigration.com. And esta charla está en inglés. Vamos a regresar con una charla en español como a las 2:30 cuando terminamos con esta charla aquí en inglés. Mm-hmm. Okay, great. Well, Maya, do you have anything to add to that so far?
Yeah, just remember that every case is different and to consult a qualified, experienced immigration attorney about your case.
Thank you. So we're going to start off a little bit with some common questions that we get. Maya's going to give us the questions, and we'll see if we can do our best to answer them. We're not going to be able to cover all the details, but we'll do our best to answer some of the most common questions, as well as some of the issues that come up.
All right. Mm-hmm. So what if I'm engaged or married to someone outside of the U.S.?
Well, that depends on whether or not you're a citizen or permanent resident. So if you're a citizen and you're married to someone who lives outside the U.S., you can file a petition for them, and then they can go through consular processing to come to the U.S. as a permanent resident. Now, if you're a permanent resident, then you can't file. You can file a petition for them to come here, but if it's a quicker process if you're a citizen. So I would look into the naturalization process. If you're a permanent resident and you've had your permanent residence for at least 4 years and 9 months, you could be eligible to start the naturalization process to become a citizen, and that helps out to move it along. Now that's if you're married to someone. Mm-hmm. Now if you're engaged, then if you're a citizen, you can file for a fiancé visa for them to come here. Also, they could come here on a tourist visa, then you get married here in the U.S. There's a number of different options, so it depends on what your preferences are, as well as the timetable you have. And that's something I'll be happy to discuss in more detail about your case.
All right. Okay. What if I am engaged or married to someone who is in the U.S. right now?
Okay, great. That again depends on a couple different things. One, depends on how they got to the U.S., as well as whether you're a citizen or a permanent resident. So let's say you're a citizen and your significant other came to the U.S. with a visa, with mm-hmm. inspection. Then that means that you could file a petition and application for permanent residence at the same time if they don't have any other types of bars, and all they did was overstay their visa or their visa is current. Now, if you're a permanent resident and your significant other came here with a visa, then one of the issues there is that they can't have overstayed their visa. So one thing I would recommend is for you to look into becoming a citizen, and then it doesn't matter if they overstayed their visa or not as immigration is concerned, and they could do the whole process here. Now, the other issue is if they came in without a visa. Now that complicates it a little bit because in general, if someone comes to the U.S. without a visa, then they have to file a waiver. There are some exceptions to that, and one of them is what's called 245I. That's if the person had a petition filed that was a valid petition, like a family petition or employment-based petition, prior to May 1st, 2001. Then they can pay a fee and continue the process here. That's one exception. Another would be something called advance parole. Mm-hmm. If someone, for example, has or had DACA and entered without a visa, but then did advance parole, which allowed them to leave and come back with permission. Now the issue there is that currently the Trump administration is not allowing people to do advance parole. So you would have had to do it in the past. I know there was an announcement about DACA. Now we're talking about DACA. Yesterday there was a court order in federal court that kind of reinforced the federal court order we had in California last month about restarting the DACA option. So that's just for people who currently have DACA or have had DACA in the past. You can renew your DACA, but you can't, at this point, file an initial DACA application or request advance parole, unfortunately. So that brings it back to, without one of those exceptions, then generally what you need to do is file a waiver. One other exception I forgot to mention is TPS. Mm-hmm. So if you have TPS, for example, and you're married to a U.S. citizen or permanent resident, you can request TPS. You could just advance parole based on TPS, which allows you to go outside the U.S. for a really important reason and come back with status or with a valid entry with inspection. Now you have to file before you leave, so don't leave without having that approved first. But that's just something to know about to continue the process through your spouse. Now, if you don't have one of those exceptions, then you generally have to file a waiver. This is for people who are married to someone who's a permanent resident or citizen. They live here in the U.S. and they came in without a visa. Now, unless you have some other type of bar, whether it be like a criminal bar or a bar based on too many entries into the U.S. after staying here for more than a year, then you could file a waiver. And that right now they offer a provisional waiver, which allows you to file the waiver here in the U.S. and that waiver can be approved prior to leaving to doing the consular interview in your home country. So that's it's a complicated process, but something we do a lot of. We've been pretty successful with them, but they are a little complicated and involve showing a lot of good faith marriage, but also hardship on your spouse who's a U.S. citizen or permanent resident if you can't stay here. So that's a little bit about immigration options for someone who's already here in the U.S.
All right. Well, what about if I'm married to someone with an approved or pending U visa?
That's a great question. So when someone files for a U visa, and U visas are for victims of serious crime, then you can include a spouse and also minor children in your U visa application. But let's say for some reason you didn't include your spouse at the time that you filed for your U visa. Well, if the U visa is still pending, you can add on your spouse as long as you were married at the time of when you first filed. But if you weren't, or if your U visa is already approved, then you can file an application to include your spouse later. You have to show hardship, so it's more complicated, but that also is a possibility if you're married to someone with a U visa or who has a pending U visa.
All right. Well, someone told me about the 10-year law defense.
Yeah, so that's a great question about the 10-year law. That's something I get a lot of questions about, and unfortunately, there's not a lot of truth to how it works. So there is no 10-year visa that someone can file for. Now, there is a defense to deportation called cancellation of removal, and it's only for people who've been here at least 10 years and can show that a family member will suffer extreme hardship if they can't stay here in the U.S. Problem is, you have to be in removal proceedings in order to request it. So it's really just a defense to deportation. But what some attorneys and notarios have done in the past is file an asylum application. And in most cases, the person isn't eligible for asylum because they've been here more than a year. But the asylum application allows them to get a work permit, and it also gives them a path to, once that asylum application is denied, being in the immigration removal process, the deportation process. But the thing is that a lot of times the applicant doesn't know the risks, because after your asylum application is denied, you're going to receive a date to show up in court, and if the judge denies your case, you get a deportation order. So it's very risky. That's why I don't really recommend doing that. But that's what the 10-year law is. It really doesn't exist. It's just cancellation of removal.
Okay. And then what if, like, I don't have access to any of these options? Like,
yeah, well, I definitely recommend talking to an immigration attorney about your case to see what options are available. But if unfortunately you don't have one, then what I recommend doing is putting together an emergency plan, knowing your rights, and also putting in a plan that includes a power of attorney that you can use to protect yourself as well as family members. Most people want to protect their kids. Like, what's going to happen with your kids if you're removed from the U.S.? You can also include things like what to do with your bank accounts or work benefits, that kind of thing. One thing I recommend is we have a brochure on your rights, and I would take a look at this. It's also on our website, loveimmigration.com, and you can take a look at it. A lot of information on what to do if the police or immigration come to your workplace or your home, as well as preparing a plan to protect yourself as well. So now we have some time. We're going to check some of the questions that we've gotten in.
let's see.
Let me show you real quick. I think it's over here.
No, it's up there.
You see it? Is that it?
It's up there.
I thought it was on the video. Here we go.
Yeah.
You already knew it, right? Never mind.
All right. So, what if your spouse has one involuntary leave, which was 9 years ago on record? He's never been in trouble and has always paid taxes, married to citizen, and has children. But they didn't specify gender, so they never have.
Yeah. Which one are you reading?
This one.
Oh, okay, good. Involuntary leave. It depends on, okay, that's a great question. So what happens if your spouse has an involuntary leave, which was several years ago? Well, that depends on what you mean by involuntary leave. One thing is called there's a voluntary return, which is one thing, and that's usually when someone gets stopped at the border. They're not here in the U.S., but they get stopped on trying to come into the U.S., and then they're basically fingerprinted, held for a little bit, and returned to Mexico generally. So that's usually not an issue as when it comes to an immigration option such as filing for the waiver. But I would recommend, if there's any encounters at the border, filing a FOIA request. That's Freedom of Information Act, FOIA. Just to double check and make sure there weren't any issues that would affect someone. Because sometimes someone's just returned to Mexico. Other times there actually are processed and do receive an order of deportation or a voluntary departure. And that could be a problem if they then re-enter the U.S. without waiting the specific period of time, sometimes it's 5 years, sometimes it's 10. Generally it's 10 years if they were here more than a year. But if someone is stopped at the border on the way in and given a voluntary departure, then it's just 5 years. So it depends on the case, but it could affect your immigration case. Just feel free to give me a call and I can chat with you about that more.
All right. We have another one. If a citizen marries someone who has DACA, will they be able to get a green card since they married a citizen?
That's a great question. So it depends on a couple things. One, if the person with DACA came in without a visa, then so let's start here. If the person came in with a visa and has DACA, then they can do the whole process here. They don't have to leave or file a waiver unless there's a criminal issue. But if they came in without a visa and then got DACA, then it depends on when they got DACA. If they had DACA before they turned 18 and they have less than 6 months of time when it may have lapsed in the middle before they were able to renew, then as long as they maintain their DACA status, then they don't need a waiver. And they will have to consular process, but there's no bar, so they shouldn't have any issue. Now, if they have overstayed for more than 6 months after turning 18 without DACA, or they were older than that when they got DACA, then they will have to file a waiver, just like other people do who don't have DACA.
Okay. And we touched on this already, but can we submit new applications now or renewing for existing DACA? Yeah,
as of right now, unfortunately, we can't submit new applications for DACA. I haven't heard any changes to that. I know there was a court order yesterday about DACA. From everything I've read, and I apologize, this just came out yesterday, so I haven't had a chance to read all the details in the case. But it looks like, as of right now, they're only accepting renewal applications for DACA, including people whose DACA has been expired. You can still renew if your DACA is expired. But as long you have to have had DACA at some point in the past in order to request DACA right now.
Okay, and then Angel, your question is in Spanish. Do you want to answer it in English, and then we can answer it again in Spanish in a minute?
Yeah, I'll check this question right here we got in Spanish.
Una petición aprobada por parte de mi esposa, pero mi récord está un poco mal y no puedo calificar para el perdón. ¿Habría alguna manera de tratar de arreglar mi récord para poder aplicar para el perdón?
Okay, wait. That question involves if someone they have an approved petition through their spouse who's a citizen or permanent resident, but they have an issue with a prior arrest or some type of prior criminal record. Well, the provisional waiver, which is the waiver that you do here in the U.S., it's only for coming in without a visa. It doesn't. It's not a waiver of any criminal issues. You can file a waiver outside the U.S. for any criminal issues that have come up. But the problem with that is if it's denied, then you're outside the U.S. and you can't come back. So, I would take a look at it because not every crime is a bar to filing a waiver here in the U.S. So I would definitely talk to an immigration attorney about your case to see if any criminal issues you've had in the past may be an issue. It depends on what it was. It also depends on how long ago it was. But there are certain crimes that, especially crimes of violence or fraud, that could always be a problem. But it depends on what they are. So that's a good question. The other issue was about trying to fix your record here in the U.S. Well, that's something you would talk to a criminal defense attorney about. In certain cases, you can reopen a criminal conviction depending on what it was, and also depending on if you had an attorney represent you before. It's possible you may be able to open it. Or if you had an attorney but they didn't tell you what the immigration consequences were, then maybe you could reopen it and try to, maybe not clear it off your record, but plead down to something that may not affect your immigration case.
All right. I think that's all the questions we have for now.
Okay.
Yeah, well, thank you for joining us.
Yeah, happy Valentine's Day, everyone. Hope you're having a great day. Feel free to reach out to us at 205-323-8727 if there's anything we can do to help out with your immigration case. Also, we're right here in Hoover, just outside of Birmingham. We also we have an upcoming event as well.
Yes, we have an appointment day in Huntsville, so give us a call if you'd like to schedule an appointment on February the 28th.
Yeah. Well, great. Thanks again for joining us.
Yeah.
Yeah, give us a call.
Okay.
Give us a call, and we'll be happy to answer any questions you have or schedule an appointment here or in Huntsville on the 28th. I will be back soon. We'll be doing a chat on petitions and waivers, because there are certain people who can file petitions and certain people who can do waivers. It's kind of complicated, so we'll cover that in more detail next time.
All right. Happy Valentine's Day. Bye, guys.
Thank you very much. Bye.